Good morning. My name is Dave Jones. I'm the Insurance Commissioner for the State of California, and I want to welcome you to this investigative hearing. Present with me on the dais are our State Controller, John Chung, Belinda Miller, the General Counsel of the Florida Department of Insurance, Paul Hansen, Director of Enforcement for the Minnesota Department of Insurance, and Adam Cole, General Counsel for the California Department of Insurance. We'll be joined shortly by Rick Chavarro, General Counsel of the California Controller's Office. The purpose of today's hearing is to investigate practices in the insurance industry regarding the payment of death benefits under life insurance policies and annuities. State controllers and state insurance regulators of a number of states are examining life insurance companies to understand whether they are using information they have that indicates a policyholder has died and whether they are paying out benefits once they have that information. Initial information from publicly available sources suggests some troubling practices in this area. For example, initial information indicates that life insurers receive detailed information about the death of their policyholders from a database prepared by the Social Security Administration called DeathMaster. Insurers use DeathMaster for a variety of purposes. Some insurers appear to use DeathMaster to cut off payments on annuities when an annuity owner dies, but do not use that information to identify life insurance policyholders who died and pay their beneficiaries. Further, initial information indicates that some insurers pay premium to themselves from the built-up cash value of a policy after a policyholder dies, even though the insurer has notice of the death from the DeathMaster data file or another source. In that situation, not only does the beneficiary receive no payment, but the insurer increases its revenues by draining the value out of the policy until there's nothing left. We are troubled about the possibility that insurers may be using death information to boost their finances by stopping annuity payments on one side of their house, but not using that same information on the other side of their house to pay policyholders whose beneficiaries are due benefits. More generally, we want to understand what insurers do to investigate the deaths of their policyholders and pay beneficiaries who are owed money. We have subpoenaed Metropolitan Life Insurance Company, generally known as MetLife, to testify under oath before us today to answer questions about its practices in this and related areas. MetLife is one of the largest life insurers and issuers of annuities in the United States. It has substantial market share in California. I'm very pleased today to be joined by our State Controller, John Chung. I want to commend Controller Chung for his initiation of an investigation into death benefits and unclaimed property held at insurance companies, and for the extraordinary work of his department and his staff, and he personally, on this issue. We're very excited at the Department of Insurance to be working closely with the State Controller and the State Controller's Office on this matter. While our focus today is on MetLife, we're looking at practices around the industry. As of today, I have commenced market conduct examinations, which are investigations of 10 of the largest life insurers in the United States to investigate their practices as well. My comments this morning are based on preliminary information about practices in the industry. Our purpose today is to get more definitive information about these practices. This hearing is a part of a coordinated multi-state investigation by insurance departments and controllers around the United States. Minnesota and Florida insurance regulators are participating in this hearing. We will be sharing information from this hearing with other state regulators and continuing to cooperate with them on this multi-state investigation process. Today's hearing will proceed as follows. After my opening statement, Controller John Chung will make an opening statement. Then General Counsel Adam Cole will provide some additional background to further set the stage for the hearing. We'll then swear in the participants from MetLife and question them, and following that, we'll provide an opportunity for members of the public to make comments. We want to welcome the representatives from MetLife to the hearing today. We'll take one 15-minute break in the morning, recess for lunch around 12:30 to 1:30, and take one 15-minute break in the afternoon. And with that, it's my great pleasure to introduce our state's controller, Controller John Chung.
Thank you, Dave. Thank you very much for the invitation to participate in this morning's hearing, and good morning to all. In July of 2008, my office initiated audits of the life insurance industry to determine whether the industry was complying with California's unclaimed property laws. Specifically, I was concerned that insurance companies were holding on to the proceeds of life insurance for years and sometimes decades after the insured had died. I was concerned that the life insurance industry was ignoring information that it had access to, which would identify deceased clients and enable the company to pay those benefits to either the insured's beneficiaries of the state of California or to the state of California so that we could return those benefits to the beneficiaries. All too often, for one reason or another, we know beneficiaries under life insurance policies fail to come forward when their loved ones die. There are many reasons why. Parents may buy life insurance policies that their children, perhaps adults when the owners die, do not even know about. Or the children may be raising families of their own in different states, unaware of an old policy that sits in a dresser drawer or in a forgotten safe deposit box. But let's be perfectly clear. The insurance companies know about these policies, even if the beneficiaries don't. That's where my office comes in. If life insurance benefits are not claimed by the heirs, those benefits are required to be sent to California's Controller's Unclaimed Property Program, where we can safeguard those funds until the beneficiaries come forward. Back in 1948, the Supreme Court of the United States recognized the important role all 50 states play in this process. The court, California statutes, recognize that the state is a far better repository of those unclaimed death benefits than an insurance company. That's because an insurance company may go out of business, or it may merge with another company, or it may simply use, lose, or draw down those unclaimed death benefits. But the state of California will hold those unclaimed death benefits in perpetuity until the beneficiaries are located or come forward to claim the benefits. Here are my concerns. I believe the insurance industry is sitting on hundreds of millions of dollars in unclaimed death benefits that should be turned over to the state. I am also concerned that the insurance industry is ignoring its obligation under California laws and the laws of other states, and I am concerned that the insurance industry is not holding up its end of the sacred bargain it struck with its clients when it issued life insurance policies in the first place. The laws in this regard are clear, but what is even more clear is that the insurance industry has a moral as well as a legal obligation to pay death benefits. When you think about the expectations of all the parties, they are simple. The clients who purchase life insurance policies to protect their families after they die fully expect that the benefits will go to their loved ones upon their death. The beneficiaries and heirs of a life insurance policy owner, if they know about the policy, expect that they will receive the benefits upon the death of the insured. And finally, the insurance company at least should expect that after issuing a policy and collecting premiums for months and years, it will one day pay out the death of an insured. The questions that we are going to consider at this hearing are, have those expectations been met? Is the industry doing all it can do to pay the loved ones of its insured clients upon their death? And finally, is the insurance industry complying with its contractual, moral, and legal obligations? Today's hearing today is the continuation of a process that will allow us to do so and hopefully get some answers to these questions. Again, Commissioner Jones, thank you for the opportunity to participate.
Thank you very much, Controller Chung, and we appreciate your department and your personal involvement in this process, and thank you for your leadership on this issue. Next, we're going to have an opportunity to hear some additional background information that will be presented by Adam Cole, the General Counsel for the Department of Insurance. We want to direct your attention to the magic screen that is descending from on high, and turn the mic over to Adam.
The purpose of our hearing today is for the California Commissioner of Insurance and our Controller to evaluate potential industry-wide practices related to several areas: life insurance and annuities claim settlement issues, use of the Death Master database that Commissioner Jones referred to, compliance with California's unfair claims practices law and other insurance statutes. That's the insurance side of the laws at issue here. And finally, compliance with California's unclaimed property laws. That's the controller's side of the laws at issue. Life insurance policies. I want to just say a couple of words about what life insurance policies are and what annuities are, because we're going to be discussing those issues at some length. There are two primary types of life insurance: term and whole life. In a term life policy, the insured pays a premium for a limited period of time. If the insured dies when the policy is in force, a death benefit is paid. There is no cash value, and the policy lapses and no death benefit is paid after premiums end. By contrast, a whole life insurance policy is a policy in which the insured also pays premium. In addition to a death benefit, there is a cash value that builds up over time. If an insured stops paying premiums, the insurer may itself pay itself premium out of the cash value. The policy pays a death benefit so long as the policy is in force through one of these premium sources. And group life insurance is either term or whole life insurance coverage covering a group of people, usually employees of a company. These benefits that are offered under a life insurance policy often kick in many, many years down the line, so it's fair to say that a life insurance policy is a long-term promise by an insurer. Annuity contracts. What is an annuity contract? It's a contract by an owner and an insurer where, in exchange for premium payments, the insurer promises to make periodic payments to a person called the annuitant, whoever's going to receive those payments. And there are a variety of different types of annuities. Annuities are either in the pay-in stage or the deferred stage, which is the stage where the person who has purchased the annuity is still paying premiums in and awaiting the benefit that will eventually come to him or her. And then annuities go into the payout phase. That is, after all of the premium has been paid in, the insurance company then pays out the promised benefit. Payments begin on a maturity date or annuity commencement date. That's the date where the payments are triggered. Payments may be for a guaranteed period, for life, or for both. Payments generally are due upon the death of the owner or annuitant. That's an additional benefit. A death benefit is typically associated with an annuity. And again, as with a life insurance policy, since payments from the insurance company typically arise many years later, it's also fair to say that an annuity contract is a long-term promise by an insurer. The problem of unpaid benefits. The existence of unpaid benefits under both life insurance policies and annuities is a problem in the industry. To quote from a New York Times article in February of this year, hundreds of millions of dollars in life insurance go unclaimed each year for one simple reason: the beneficiaries do not know the money exists. It is difficult to accurately estimate the extent of unclaimed life insurance policies. A professor emeritus at Indiana University states in that same article, "Whether the companies have good record keeping, I honestly don't know, but I strongly doubt it." The potential violations of California insurance laws, and this is what the Department of Insurance is looking into. I will place a few of these statutes on the screen, but the principal point here is to indicate that a number of our laws on the insurance code are implicated. Perhaps most significantly, our Unfair Practices Act, which is a law that requires insurance companies to make sure that they engage in fair and timely claims settlement practices. In California, it is illegal for an insurance company, and I'm quoting now just two provisions of the statute, to fail to adopt and implement reasonable standards for the prompt investigation and processing of claims arising under insurance policies. And secondly, it is illegal for an insurance company not to attempt in good faith to effectuate prompt, fair, and equitable settlements of claims in which liability has become reasonably clear. There are several statutes of ours which refer to the timing on which payment is to be made by an insurance company to a beneficiary, and in essence the short answer is that whenever possible, payment is to be made within 30 days after the death of the insured. Interest runs from 30 days after the date of death of the insured, and those are laws that are also at issue here. Further, two additional laws on the California Insurance Code that we, as a condition of granting certificates of authority or licenses to insurance companies, need to be comfortable that the insurance company's management is exercising competency, character, and integrity. We look at whether claims under policies are promptly and fairly adjusted, and we look at fairness and honesty of methods of doing business. And finally, on the insurance laws, we also look, as a condition of certificates of authority being held, at whether insurers are carrying out their contracts in good faith. On the unclaimed property side that the controller will be looking into, the question has to do with escheat. Escheat is the process by which funds or monies held by an entity, such as an insurance company, which are abandoned or unclaimed, are then turned over to the state, which then attempts to find the owner. California has a law on its unclaimed property books that require insurance companies, after 3 years of dormancy of an insurance policy, that it be turned over to the state for to the controller's office. And I want to comment just very briefly on a case that Controller Chung referred to, a 1948 case, Connecticut Mutual versus Moore. This is a significant case because the U.S. Supreme Court at that time determined and held that state controllers' offices and escheat and unclaimed property departments have a very strong interest in making sure that benefits get into the hands of policyholders, and that the terms of a policy itself, which may require presentation of a death certificate, are overridden by the state's interests. What we're looking at here are questions as to whether insurance companies have information indicating that consumers are deceased with active policies, but fail to act on this information except when it is in their best interest to do so. Whether insurance companies have failed to pay death benefits or escheat death benefits in situations where the insurance company has information that individuals have died with policies in force, but beneficiaries have not actually filed claims because they were unaware of a policy. Do insurance companies have adequate controls to monitor when retained asset accounts have been dormant and to try to locate the owners or escheat the benefits? A retained asset account is a mechanism that insurance companies, life insurance companies, have to hold money after someone has died that belongs to a beneficiary and is held with interest for some period of time until a beneficiary comes forward and says, I want to take all or some of that money out of the retained asset account. Different ways insurers become aware of the deaths of their customers. There are a number of sources that can give rise to information about this. For example, relatives or representatives of a person who has died can call or send a letter to the insurance company. That's short of filing a formal claim. The insurance company, when searching for new addresses, gets return mail. Claims filed and or death certificates received in connection with other policies or contracts insuring that same person. Information from Deathmaster, which has been referred to. What is the Deathmaster file? Just a few words about this. It is a very prevalent form of death information available in the United States. It is a product of the Social Security Administration. It contains today about 87 million records of people who have died, and the information in Deathmaster is quite comprehensive. It includes Social Security numbers, addresses, names, dates of birth, and other information. Deathmaster is very, very accurate, 99.5% accurate, in fact. In congressional testimony given by the Deputy Commissioner of Systems at the Social Security Administration that oversees Deathmaster, that person, Bill Gray, has testified that the death data that we maintain is 99.5% accurate overall. How is Deathmaster accessed by entities such as insurance companies? Well, there are a number of available tools, commercially available programs and subscription services that insurance companies and others subscribe to. We've just thrown a few of those on the screen, which enable insurance companies to access this information. There is a potential problem, which we are looking at today, about selective use of Deathmaster. That insurance companies may be using Deathmaster for certain purposes. For example, to perform anti-fraud procedures, to verify dates of death prior to paying out on a policy, to perform what have been referred to as death sweeps of large corporate accounts, performing regular comparisons against their records to identify deceased annuity holders in the payout phase and to stop making payments under their contracts. That is, once that payout is due, the insurance company looks at Deathmaster, determines someone has died, and stops paying the annuity. The question we are looking at here today, among others, is whether insurance companies use Deathmaster regularly against their life insurance policies to determine whether a life insurance policyholder has died and to get money into the hands of beneficiaries. What happens when there is a match of a policyholder in an insurance company's files with a reading on Deathmaster? And these are questions that we have. Do insurers allow death benefits to go unreported or unclaimed even when they know through Deathmaster that an insured has died? Do insurers use policy cash values to pay themselves premium after the death of the insured, even if they know from Deathmaster that the policyholder has died? The other information on deaths that insurance companies have in their files, and what do insurance companies do when they have information but there has not been a formal claim filed by the beneficiary? I want to just give a couple examples. Example one, a phone call or letter received from a relative reporting on the death of an insured, but no claim is ever formally filed by the beneficiary. What do insurance companies do in that situation? Second example, a death certificate and a claim form are received from one of several beneficiaries, but not all beneficiaries file a claim. What happens in that situation? Third example, a search for a new address following receipt of return mail indicates the insurer is deceased, but again, no claim has formally been filed. We have questions about whether insurers allow the built-up cash value of their policies, as Commissioner Jones indicated in his opening statement, to be used to pay for the continued sustenance of the policy, even though a policyholder has died until the policy value is drained. Just to give an example here, here's the situation. Insured dies in 2005 with her policy in force. No claim is filed. 6 months later, the policy is set to expire because there have been no premium payments. Although the insured is listed in the Deathmaster database as deceased, the insurer begins to withdraw a premium from the cash value of the policy to keep it in force. 5 years later, the cash value of the policy has been used up and the policy is allowed to expire without any value. Question, what happens in that situation? Is that happening here with insurance companies such as MetLife? Dormancy period calculations for escheatment. This is the controller's set of issues. And the question is how insurers calculate the dormancy period for escheatment, and that means the number of years a claim goes unpaid before it is considered unpayable and has to be turned over to the state. Do insurers rely on something other than the actual date of death in calculating that time frame? An example here, insured dies in 1989 with a policy, no claim is filed. A Deathmaster file comparison performed in 2009 identifies the death of the insured 20 years earlier. The insurer verifies the insured died while his policy was in force. No benefits have ever been paid. When will the insurer consider the proceeds due to be escheated? And it should be noted that improper calculation of a dormancy period allows insurers unlawfully to retain millions of dollars in proceeds for years, if not decades, after they are due to be escheated. I want to just mention a few words about a concept, demutualized insurance companies, because this may come up in some of the questions. In the late 1990s, many large insurance companies demutualized, and that required them to contact all their in-force policyholders. And demutualization means that you are a mutual insurance company. Your owners are your policyholders exclusively. A stock insurance company is an insurance company whose owners are members of the public like any other stock corporation. Insurance companies sometimes convert from one of those forms to the other. In the late 1990s, large demutualized insurance companies acknowledged as part of a process of trying to, and I should say in this process, the insurance company, when it turns itself into a stock insurance company, is required to go out and try to locate all of its policyholders because they're going to become stockholders and they need to get their stock or some cash payout. So a demutualization process requires a search to find policyholders. Large demutualized companies acknowledged that they had in fact lost contact with many of their policyholders at the time of demutualization. What searches, including use of Death Master, did insurers perform that allowed them to identify which lost policyholders were actually dead? What did the insurers do if they determined that an insured was deceased? Over a decade later, are these insurers holding on to unclaimed death benefits due to any of these lost or dead policyholders? These are questions that we have. I want to mention industrial policies very briefly. An industrial policy was a form of policy issued many, many years ago. Small face value policies, often sold door to door with premiums collected weekly or monthly. The demographic of the owners of these policies typically was lower income individuals. The policies were, as stated here, and sometimes the premiums ended up being more than the actual benefits offered under the policies. There are millions of these policies in force industry-wide today. What is the quality of record keeping for these policies, some of which were issued more than 50 years ago? What did insurers do if they determined that an insured was deceased? What have insurance companies done to determine which of these insureds are deceased and what benefits are due? And last, I just want to mention retained asset accounts very briefly. I referred to it earlier. The retained asset account is in fact quite significant. $28 billion is held in the United States in retained asset accounts by life insurance companies. This is money that is understood by everyone to belong to a beneficiary. It is sitting in insurance companies' accounts. Many insurers use them as their default method of payment. They are a short-term option that insurers refer to enable people to sort of get over a period of grieving, and then the money is going to be turned over to them. And there are issues about the accounts not being guaranteed by the FDIC. But the point that we're focused on is a retained asset account held by an insurance company, owned by a beneficiary. The beneficiary does not come forward for some period of time. What does the insurance company do with the money in that account? And with that brief background introduction, we will then proceed to questions.
Thank you very much, Mr. Cole. And I think we can have the lights come up now. Good morning. Again, I want to welcome the representatives of MetLife to the hearing. I see that we have 5 individuals seated before us. In a moment, we'll put those individuals under oath who are planning to testify, but for now I'm just wondering if we could proceed from my left to your right, and perhaps you could just identify yourself and your title.
Good morning. Teresa Wynn Roseborough, Deputy General Counsel, MetLife.
Good morning, everyone. Bob Solman, Executive Vice President, Retirement Products.
Good morning. Todd Katz, Executive Vice President, Insurance Products.
Good morning. Frank Cassandra, Senior Vice President, Insurance Products Finance.
Good morning. Brad Berenson. I'm with Sidley Austin. I'm outside counsel to MetLife.
Welcome. Which of you will be testifying this morning?
3 of us.
Very good. I'm wondering if the individuals who will be testifying, and I believe it's Mr. Solomon, Mr. Katz, and Mr. Cassandra, if you could raise your right hand, and I'll administer the oath to you. Do you solemnly state, under penalty of perjury, that the evidence that you shall give in this matter shall be the truth, the whole truth, and nothing but the truth?
I do.
Very good. I understand that counsel wants to put on the record a reservation of rights.
Thank you very much. Very briefly, Mr. Commissioner, I appreciate the opportunity. MetLife is here to address all of the topics that were identified in the subpoena and that were the subject of the PowerPoint that has just been presented, and is looking very forward to doing that. Prior to this session, there were meetings with your General Counsel, with Mr. Cole, at which the scope and format of this hearing were discussed. Following those meetings, MetLife did communicate to the Department certain objections and reservations based in law to the scope and format of the hearings, particularly to the extent that there might be questions that call for the disclosure of information that would ordinarily be protected as a trade secret, or that would be private customer information. We don't anticipate any particular problems this morning, and MetLife intends to cooperate fully with the hearing. But I did want to make clear that nothing we say or do here today is intended to waive those objections, and all of our rights under the law are specifically reserved. If there are questions that get into some of those areas, we'd be delighted to follow up with information in the context of the market conduct exam. Thanks.
Very good. I'm wondering, as to each of the sworn witnesses, if you could, just starting from my left, moving to my right, briefly describe your current responsibilities at MetLife and past responsibilities. And why don't we start with Mr. Solomon?
As Executive Vice President responsible for retirement products, I have the overall responsibility for our individual annuity business. Prior to that job, I held responsibilities across MetLife in the 37 years I've been with the company in mergers and acquisitions and in our institutional business area.
Very good. Mr. Katz.
Good morning. Is my mic working? Hear me okay? I'm not sure it is. No. Try to fiddle with it.
There should be a little green light lit on it.
The green light is red.
Okay. This gentleman might help you.
Okay, is that better?
That's a lot better.
Fantastic. Okay, Todd Katz. I have responsibility for our insurance products area. That includes all of our individual life products, our group life products. Prior to that, I held roles similar to that for specific smaller lines of business, like our dental business and disability. And prior to that, I was in our group department for several years earlier.
Very good. And Mr. Cassandra.
Yes, good morning. Good morning. I provide financial oversight to the insurance products in the United States. I've been with MetLife for 25 years. Prior to this assignment, I had various assignments around the company in the group insurance areas, including pricing.
Can you talk a little bit closer to the mic?
Yes, I will.
Great. And I just want to make sure, we do have a reporter that's transcribing, and I want to make sure the reporter can hear as well. Okay, so we just want to ask if the representatives from MetLife could really hold the mic a little closer. It'd be easy for both the public and the reporter to hear. One of our first sets of questions has to do with the Social Security Administration's Death Master file. For ease of communication, we're going to just refer to that as Death Master throughout the hearing. And I want to begin by just asking, to whom should I best pose questions with regard to the company's use of the Death Master file?
That would best be to me.
Okay. Are you familiar with the Death Master file?
I am, yes.
Does MetLife use Death Master?
MetLife does use Death Master, yes.
And can you explain for us how MetLife accesses the Death Master file?
Sure. That one will take just a little bit more detail because MetLife, very large organization, multiple divisions with multiple products in different jurisdictions. So the way the Death Master file is accessed would vary by area, which we can talk about in depth. As we go through this, we'll do our best to give you complete answers by area, and I can start to articulate them if you'd like. What I would say as we go through it, just as a caveat, I'm going to do my best to speak in general terms. Over the duration of our company, we've made a number of acquisitions. We've made a number of new products and different products. So while we'll try to make our answers as complete as possible, there probably will be some exceptions. And to the extent I know of an exception, I will certainly aim to reference that. So, Commissioner, I can go through each of the products if you'd like, or I can allow you to ask questions however you'd prefer.
Maybe we can start chronologically. And I'm wondering if you could tell us when MetLife first began to use Death Master.
Sure. So MetLife first began to use Death Master in the late 80s. That usage was primarily in our group annuity business. And that was a fairly manual process for a business that had records of Social Security numbers, and those records were on individuals that were in a repetitive payment mode for the most part. So the decision was made to use that both in the context of payments, but also accurate records on that information. And also just to make it a point, as that information matured and became more systematized in the 90s, there was a recognition that in that group annuity business, in situations where an individual was in payment mode and there was an indication of death, it would be a useful tool to prevent duration errors, i.e. not pay out annuity payments in error, which would be bad for the person potentially getting that money and for the company. And then I'll just add one other comment. Social Security Administration at that time also articulated that as a core usage for that information.
With regard to the company's first utilization of DeathMaster for the group annuity business, can you describe more specifically how it was used or what it was used for with regard to the group annuity business?
Other than what I just described, this was quite a while ago. So I would think of it as two primary purposes. One, accurate record keeping in terms of our policyholders, both in terms of administrative records and reserving, and accurate payment information in the same way that I described. And when it was first used, it was a very manual process back then. Unfortunately, I am not an expert as to what was going on in much more depth than that.
When it was first used in the group annuity context, then was it used to determine when someone had died and when it would be appropriate to cease making an annuity payment?
Initially, it was used more to make sure we were managing records in the right way. As the process evolved over time, it certainly was used as a means to prevent duration errors by sending a notification to an individual where we had an indication of death, advising that individual of such indication and that payments were suspended. If at any time an individual wrote back and said that that was an error, which didn't happen all that often, we certainly would reinstate that. But the process that I'm describing here was more focused on really preventing duration errors and enabling higher levels of accuracy and mitigating situations where we had to collect overpayments or an individual accidentally used those funds when they weren't entitled to do so.
What does the term duration error mean?
Sure. So if you think the way I'm using it, and I don't know if it's a legal term, I don't think it is, but if you think about payout annuities, when an individual is receiving payments, they're entitled to receive those payments for a certain amount of time in the contract or based on the regulations that govern the contract. And in most situations, when someone is dead, that is the time or somewhere around that time where either the payments will cease or the payments will change. You could have a primary payment and then it could be another individual gets the payment after that, or there could be additional proceeds payable at the time of death. So it's to make sure the claim is being paid, the annuity is being paid for the appropriate duration, and to avoid situations where it's being paid too long. That's the best way to describe it. I don't know if you want to add to that, Frank.
No, only to say if it was being paid consistent with the contractual terms. Generally, annuity contracts require that in order to receive the funds, the annuitant is alive. So the fact that an annuitant has passed in and of itself is usually enough under the contract provisions to end the company's liability or to modify it to a contingent beneficiary or to pay a death benefit.
And when MetLife first began to use DeathMaster in this fashion, as you've described it for the group annuity business, do you have, can you provide us with some estimate of the number of group annuity policies to which it was applied?
I don't have that number.
Okay. And you mentioned that it was first used manually. At what point did the company's use shift from manual to some other mode of use?
Yeah, so this is, I'm going to do my best around history to be as accurate as I can, but I'd ask that you appreciate that some of these dates happened a long time ago. So in the 90s, I'll characterize it in the mid-90s, moving into the latter part of the 90s, as technology advanced, opportunities to systemize our processes became more apparent to us. and there were a number of different enhancements over that period of time to go from a more manual to a more systemized approach.
Can you identify more specifically when in the 90s the company began to use DeathMaster in a more systemized approach?
I'd prefer to say it's in the mid-90s. I can't give you a specific date because it evolved sort of over time. So we certainly can respond back to you with more clarity on the different enhancements and when they happened. I just don't have that at my fingertips.
Okay, then with regard to the use of DeathMaster for the group annuity business, is it true then that as it used DeathMaster for the group annuity business that payments would be stopped for annuitants whose name is showed up in the DeathMaster file?
I would say no, not just the name, Commissioner. So we would do a match using the Social Security number and the month and year of birth. And if a match was identified, the payment would be suspended, and we would reach out to the family member to determine and to verify that, in fact, that person had passed.
Mr. Cassandra, can you please speak very closely into that microphone?
Yes, I will try.
Very closely.
Were any of the policyholders who had annuities through the group annuity policies, were they also policyholders who had life insurance policies with MetLife?
I can't tell you definitively which ones had which, but if in fact we became aware that an individual had life insurance, we certainly would have attempted to reach out to that beneficiary and make good on those claims.
But with regard to the group annuity business, is it the case that most of those holders of those policies also hold corporate or group life insurance policies?
I don't know the answer to that, but generally speaking, I would look at those as separate. I wouldn't think of it as an employer would buy annuity business and group life business concurrently. If you think about the group annuity business, some of those policies were older in nature, and once they're on our books, generally would stay on our books. Where group life insurance, generally the employer is managing the records, and that business is more inclined to move from company to company. So if you're theorizing, hey, if you've got the group annuity business, do you generally have the group life insurance business too? I wouldn't say that's usually the case.
Did MetLife, on a routine basis, use DeathMaster to identify those who had life insurance policies who also had annuities through a group annuity policy?
So we did not apply the DeathMaster index to our group life business. And the main thing that I should point out there is for the group life business, for the most part, the employer has the records. It's a very important distinction. So we're not in possession of who's covered in the vast majority of our group life business. The employer is the one who's maintaining that information and sharing with us information when an individual is dead, generally speaking.
With regard to annuitants that you were identifying as having a match under DeathMaster, was any effort made simultaneously to determine whether that annuitant had a life insurance policy, either individual, group, or through any other form of placement of that life insurance policy?
So you're asking back historically or
let's stick with the period of time we're talking about. You told us late 80s to mid or late 90s. DeathMaster was used for your group annuity business. I'm asking during that period of time, was DeathMaster simultaneously used? If you had identified someone who had an annuity on the group side, did you simultaneously look to see if they had a life insurance policy from the company in some way, shape, or form?
I do not know the specific detailed answer back from then exactly what was done. Again, we certainly can follow up there.
But you're not aware of a systemic effort by the company to do that sort of match?
We certainly have had procedures to share information within the company. Those procedures vary by area and vary over time, so I want to be careful not to lead you down a path to we did something or didn't do something because it was a while ago and it may have been different by area. So,
Okay, so you've testified that the company began using DeathMaster manually and then in a more systemized way with regard to your group annuity practice. Did you use DeathMaster for any other part of your business? And if so, when did you start using it for those other parts of your business?
so we have used DeathMaster for other parts of our business. I think for today, we can talk maybe next about our individual life business, if you'd like, or would you like us to speak to our individual annuity business, or
I
list
think,
them?
what was the first next chronological use of DeathMaster, if you will? You've talked about your initial use for the group annuity practice. What was the first next chronological use of DeathMaster?
I'm going to ask my team for the, let me do this. Let me talk to, go ahead.
For business uses unrelated to litigation.
Okay, I'm sorry.
Yeah.
We should have you on the mic, and if you're going to testify, we need to put you under oath, or is it just you're trying to clarify the question?
This is a legal point, so I'm just isolating that they're discussing today business use outside the context of litigation. So with that context in mind, I think the next use would be something that Mr. Solomon could speak to.
Let me just begin by saying that, and Adam, I think you touched on this in your presentation. You know, by far the most frequent method that we learn of a death from is from an agent or broker or a family member or even a funeral home. And part of that is because in the annuity business, both on the payout side of our business and also because of the deferred business, we're in frequent contact with the contract holder and their family, typically, through, of course, periodic payments of payout annuities to the owner, as well as on the deferred business, quarterly statements of their account value, annual prospectus mailings, privacy notice, and so on. Nevertheless, it's my understanding that beginning in the early 2000s, with respect to the individual annuity business, we began to use the DeathMaster to conduct periodic sweeps for both payout annuities and for deferred annuities on some of our administrative systems that support the majority of our most mature blocks of annuity business. As we continue to evolve and systematize our procedures in this area, we plan to expand these sweeps this year throughout our entire block of deferred annuity business as well. In general, these sweeps are conducted monthly for payout annuities and quarterly for deferred annuities. When we have an indication of death from any of these DeathMaster sweeps, or frankly from any other source, we seek to confirm that death by sending a notification or a death claim packet to the last address that we have on file. With respect to payout annuities, payments are suspended at that time. Now, if we don't hear back, we have an established process of following up at regular intervals for up to 5 years from the date of death. The 5-year period is important because in annuities, for annuities, death payments are considered taxable income. And while I'm not a tax expert, the Internal Revenue Code allows the beneficiary to defer the collection of that death benefit for a maximum of 5 years. If we find that the last address is invalid through that 5-year period, then we will generally put the case through something we call a finder process, where we try to identify look for a valid address. If after a year we can't locate a valid address, then we would follow our standard escheatment procedures.
Okay, so this is now for those who have individual annuities. This is different from the group annuity that was testified to a moment ago.
That's correct.
Okay, so when did you start undertaking periodic sweeps for both payout and deferred annuities in the individual annuity context?
Generally speaking, beginning in the early 2000s.
And as to payout annuities, you do those sweeps monthly. As to deferred annuities, you do those sweeps quarterly.
That's correct.
With regard to both of those classes of individual annuitants, did MetLife, during this period of time, also undertake to determine if there was a match on the individual annuity side as to whether that individual annuitant also had a life insurance policy issued by MetLife?
So first I would say that I'm not aware of any specific case where this has been an issue, where in fact we might have been looking for or verifying a death claim on the individual business, but had left a life insurance claim for that individual outstanding for some period of time. Nevertheless, it is my understanding that we do have a variety of systems and procedures across our business that have been developed over some period of time that do inform other product areas. We have continually been evolving those procedures and processes over time, and in fact, it's my understanding that recently we took additional steps to document and formalize these procedures.
Okay, so again, just chronologically, when did you begin to actually check to see if a individual annuitant also had a life insurance policy in the context of there being a death master match?
I think those processes evolved over time. I don't have the specific dates when that began. As I said, I think it evolved over time through more informal processes, and then more recently we systematized that process.
Was it this year?
I'm not aware of what year we began.
Was it 2 years ago?
I can't say. We can follow up and give you more specific information about that.
Can you tell me whether it was in the last 5 years?
I'm not aware of it being within the last 5 years. I don't know the answer to your question.
Okay, so you don't know whether it was either within the last 5 years or earlier than the last 5 years that you began to systematically look to see if a life annuitant for whom you had a death master match also had a life insurance policy?
Systematically and on a more formal basis, we began that process within the last year.
Within the last year, okay. And so within the last year, what exactly would you do when you found an individual annuitant for whom there had been a death master match? What exactly would you do with regard to that annuitant?
It's my understanding that we would pass that information along through various systems that are available to our other product areas. But beyond that, I don't have the detail with me to show you exactly how that communication would take place.
Okay, so is there anybody from MetLife that can tell us, with regard to the company's practice in the last year, how, when a match has been made on the individual annuity side, how the company goes about informing the life insurance policy side that there is such a match?
No, I don't think we can.
All right, well, that's very disappointing because our subpoena asked that MetLife provide representatives that could answer these questions. And so I am very disappointed that there's no one here from the company that can answer that question, since we were very clear in our subpoena that we needed witnesses that could answer those questions.
So just maybe I can try to help, because we're trying to answer your question as best we can, and that really is our intent. If your question is, are there procedures within the organization to share information, the answer to that is yes. What I tried to explain before, and probably, again, there's several different business units, several different products, several different geographies, and so those procedures could be different, and so we can't paint a blanket answer for you, which is, I think, what you're looking for.
No, I'm happy to take them in turn, and that's what I've been trying to do. So you first testified about group annuities and your
Right.
practices there, and then you testified that sometime more recently with regard to individual annuities, you've been doing a match vis-a-vis life insurance. And so my question is very specific as to individual annuities and life insurance, what the company does vis-a-vis finding a match on the annuity side, what it does with regard to when it discovers that the match occurs on the annuity side, what it does, if anything, to try to determine if there's a match on the life insurance side.
Commissioner, on the individual annuity side, we do have with us, I'm told, a description of the processes we use in this case, which we'd be happy to provide you at the next break.
Okay. And that's the process that's just begun in 2011.
That's correct.
All right.
And may I just ask that?
I should clarify that, not 2011, earlier in 2010.
In 2010.
Correct.
Okay.
And are you going to testify under oath that everything that appears in that document you're going to provide us is absolutely true and correct?
On behalf of my witness here, I would not allow him to claim that kind of arrogance to purport to speak to 100% of the circumstances. He will be able to testify that that's the process typically followed.
Well, no, my question was, you were referring to providing us with a document. If you're going to provide us with that document, will one of you testify under oath now that what appears in that document is entirely correct?
They will be prepared to testify that the document is correct in terms of its documentation of the process that's been settled upon by the company for executing this responsibility. Whether or not your question goes to whether the document is accurate, yes, they'll be able to testify that the document is an accurate portrayal of the process.
All right, I'd like to get someone under oath then to testify now that the information in that document is set forth in that is a correct description of everything that it purports to describe.
Okay, after they get a chance to look at the document, we can confirm that that could be their testimony.
All right, so we'll pick that. You'll give it to us at the break. You'll have a chance to review it. We'll resume, and then you can testify as to the correctness of the document. Are there any other areas of the company in which DeathMaster has been used in addition to what we've talked about so far?
Yes.
And if so, when did it begin to be used in that way?
So let's spend a few minutes talking about the individual life business. So absent usage relative to litigation, which Teresa already mentioned, I'm not going to talk to that. We used the Social Security Death Index in the individual life business in the last decade, in the 2000s. And I'll give you a couple of instances, and then I'll bring it all the way up to current. In 2004 and 2005, through discussions with a few of our regulators, I can get you the specific states, I don't have them at my fingertips, but it's just a handful. We were in discussions about the value of that information and the potential to use it to identify people who had life insurance. And either we used that information or we shared our administrative records with the regulators and they used that information as a means to identify individuals that were deceased at that time.
And those two states were Montana and New York.
Okay, and was your use limited then to policyholders in Montana and New York?
I believe that. I think there was.
At that point in time.
I think there was New Jersey too. Is that fair to say?
I'm not.
Let us validate the states. We want to make sure we get you the correct information, but we believe it is. And at that point in time, it was for residents in those states. And I want to make it clear, it wasn't necessarily us using it. In some of those instances, it may have been us giving our admin records to the states for them to use it. And we'd be happy to get you exhaustive detail on that information.
We would like that. With regard to your use of it for those 3 or so states, how did you use it, if at all?
Let me do this. Let me just, because I can't talk to that in depth, what I can do is talk to you in depth about what we learned and what we did after that, and I think I'll come back to your question through that description, and if I haven't, you can certainly follow up. So what we did learn as a result of that in 05 and 06 was there was an opportunity to use this tool as a means to improve upon our life insurance claim process. I'm going to talk about some data in a few minutes out of our 2007 run, and I think it's worthwhile to spend a little time on that data. But essentially what that data showed us was for the period that we matched in 07, that approximately 99% of the claim dollars paid over the period we studied were submitted through the normal claim practice. We found less than 1% of claim dollars paid through this match we did in 07. So let me explain what we did in 07.
But before we get to that,
Yep.
99% of the claim dollars paid were paid through the normal process.
Correct.
But the key phrase there is claimed dollars paid. That doesn't answer the question as to what number of other life insurance policyholders died
Yep.
and their beneficiaries were not paid, correct?
So let me give you.
No, is that correct?
No. It might be helpful for me to tell you exactly what we did in 07 and then bring it back. I think that explanation will.
Well, let me just stick with this phrase, 99% of claimed dollars paid. That's just of the dollars you've actually paid, 99% occurred through the claims process, 1% did not. But again, that does not answer the question as to life insurance policies where beneficiaries were not paid, what percentage had actually died and you had information about their death.
Sure. So
That's
let
a
me.
yes.
No, that's not a yes.
Okay,
I'd
go
like
ahead.
to give you the information to answer your question.
Okay, please answer the question.
Okay. The death match study we did in 2007 identified approximately $80 million in claim payments for individuals that were not paid through the normal process. Of that 80 million, approximately 50 million, we were able to locate the beneficiary and pay that money. For the balance of approximately $30 million, we were not able to locate the beneficiary. And in the situations where we were not able to locate the beneficiary, those funds were put through our unclaimed property system, ultimately to be escheated to the states. So about 80 million of funds through the match. Over that same period of time, we paid about $44 billion in claims to individuals through our normal process.
What was the 2007 death match study?
Okay, so that's what I wanted to explain. So in 2007, do you want to take it?
You can,
Okay,
I'll supplement.
Okay, so in 2007, we ran just about all of our individual life business. There was a small segment of acquired blocks that weren't included, and I can talk more about that if you'd like, against the Death Master Index. We ran that using a 3-point match, Social Security number, date of birth within 2 years, and name. We found out of that approximately 28,000 individuals whose information showed up on the Social Security Death Index and our administrative records. Of those 28,000, we found approximately 18,000 there was a liability due for those individuals. That totaled approximately 80 million. I think it was about 84 million. As a result of that, we now determined we had an indication of death on those individuals and began a process to search out beneficiaries, which we did, which ultimately resulted in the 50 million I explained. However, we couldn't find everybody, and that resulted in the 30 million or so I explained that went into the escheat process.
I would just like to add something to Mr. Katz's statement. In that 2007 match of the Death Master file, we looked at all of the vast majority of the individual business life records for policy statuses that included any policy that may have been canceled. So the question, we did not only match at that point in time the in-force cases. We looked back for any case that may have terminated for a reason other than death.
Do you know the number of policies you ran Death Master against in 2007 in total?
We ran it against, I think, approximately a little more than 10 million records, which does not exactly match to a policy. It does not equate apples to a policy, because there may have been more than one record, but it was approximately $10 million.
And what was the total number of individual life insurance policy records at that time?
We have approximately over 6 million policies in force right now. I don't know exactly what the numbers may have been at that period of time.
And you mentioned, though, I believe Mr. Katz mentioned that in 2007 you ran Death Master against almost all the individual life business. What elements of the business did you not run it against?
Yeah, over time, MetLife had acquired through a merger and acquisition process some small assumed cases from insurers that had gone into receivership. Just to give you a sense of the magnitude, we were talking about less than 100,000 policies out of the total of 6 million. And the matching of those policies is in scope for the match that we've just conducted for our 2011 match.
Let me add one more clarification there. We did not run it against policies where we did not have Social Security number. So we only ran it against policies with Social Security numbers, and that's an important distinction. And Mr. Cole had his slide about our industrial policies, which we'd be happy to testify to if you'd like. A significant amount of those do not have Social Security numbers, and as such, we've used other means over the years to try to contact those policyholders and did not use the death index match.
Do you know what number of industrial policyholders policies were in force in 2007?
I do not have the number for 2007, Commissioner. I know at the end of 2010 we had approximately 1.5 million in force.
Mr. Chung.
Could you give me the universe of policies that did not have a Social Security number?
We can give you an estimate of that as of today, and guys help me, I think it's somewhere around 800,000?
In the industrial block.
In the industrial block. So just a clarification, so for the group, why would you not have Social Security numbers? Social Security numbers really weren't collected from MetLife on a routine basis until the mid-'80s. So if you think back historically, for individual life policies, so we've got records historically where we don't have Social Security number. What we chose to do, and this is an important distinction, in the late 80s I talked to you about in the annuity business using manual processes as a means to use the death index. In the late 80s we put forth significant efforts that lasted over 10 years to locate policyholders that we may have lost contact with. It's a program called the Family Reunion Program. And in the decade from the late 80s until the late 90s, we were able to locate over 500,000 policyholders. Those were individuals that still to this date, or recently even to this year, we're now getting claims on. So we thought it was a good effort on our behalf to get in touch with people in that block. And I should make one more distinction, if you'd allow me. We made a decision for that industrial block in the early 80s to convert the majority of that to paid-up status. And that's an important distinction. So point number one, by being in paid-up status, there were no additional premiums due for policies that were in premium-paying status at the time we made that conversion. Those policies since then have continued to perform. So individuals continue to get dividends year after year after year over that period of time, but they go to the policy value. And it creates a challenge, though, because they're not sending us a bill. We're not sending them a bill. They're not sending us money. That's where we've had challenges in keeping contact with those people. We want to make sure it's clear that one of two things for that block I'm talking about are going to happen. Either a beneficiary will come forth with a valid claim that we will pay. I guess one of three things. One of those individuals would be identified on the Death Master Index. And if they were, I want to make it clear, we run it, as Mr. Cassandra said, against lapsed policies. So by doing so, if that policy happened to have lapsed, and this block, they wouldn't have, we would restore it to the original value. And then lastly, if we never did get a claim, those policies would superannuate at the end of the mortality table. And as such, if we couldn't find a beneficiary at that time, we would then escheat the funds. I may be giving you too much detail if I am.
Well, we're getting a little bit ahead. Okay. I just want to make sure that we have a complete understanding of what's happening in the company chronologically. So let me go back to 2004, 2005. Discussion, you've testified with some regulators, maybe as many as 3. You provided some of your files to those regulators. You'll identify for us who the names of the regulators are. Is that correct?
Sure.
But then also you did some internal death master matches as to the residents of those states, for those 3 states in which you were cooperating with the regulators. You did some matches against individual life insurance policies. Is that correct?
No, I'm sorry, Mr. Commissioner. I think you doubled up on that. In those cases where the state asked us for administrative records, they would have done the match, and in fact, in at least one state, they provided back death certificates to us in order for us to adjudicate the claim. So in 2004 and 2005, these instances, we were providing records and they were doing the matches for us to the best of my knowledge.
And then when they provided you with information after they had done the match, what sort of information did they provide, and what did you do with that information?
Yes, to the extent that there was, they provided back information, proof that someone had died in the form of a death certificate. We paid the benefits to the beneficiaries.
But you required a death certificate from those 3 or so states?
We didn't require it from to the best of my knowledge, we didn't require it from them. The regulators provided them to us unilaterally.
Did those regulators provide any other information with regard to whether a match had occurred or not?
I do not know.
I think what we're prepared to give you exhaustive detail about the 07 and a match on our current match. For the 04-05, we're probably not as prepared as you may like us to be to give you that detail. It was quite a while ago. So certainly we can attempt to follow up with any open questions you might have on that period.
Okay, then between the 04-05 work with the 3 or so states and the 2007 Death Master study that you've testified to, was there any other use of Death Master in addition to what you've already testified to?
For the individual life business or more?
Anywhere within the company?
Sure. Yeah, I think I got to remember the dates. You may have it.
I can take this one.
Okay.
We have used and continue to use the Death Master file in our corporate-owned life insurance products, our COLI business. To the best of my knowledge and belief, we started that in the mid-90s. And on the corporate-owned life insurance product, what happens oftentimes is that the policy owner will lose contact with the insured, which they're no longer employed, and there's little incentive for the family members of a former employee to notify the former employer of a death. So under those contracts, we're using the Death Master file as some evidence that in fact someone had passed. And if in fact someone had passed, we would seek out a death certificate in order to pay the benefits.
Mr. Cassandra, can you please speak closer to the microphone?
Yeah, maybe there's something a little wrong with the microphone.
Really close.
Okay. Mm-hmm.
So, since
I just want to give you a complete answer.
Go ahead.
So, and I don't know when we've used it. We also use it in our disability business and in our long-term care business. I am not aware of the dates, either on a break or as a follow-up. We can certainly get you the dates when that commenced. Those businesses weren't articulated in the subpoena, but certainly we have no problem sharing that. We just don't have the dates. In addition, we also use it for our retained asset account, our total control account business.
Okay, so we'll get to each of those in turn in a moment. Let me stick with the corporate-owned life insurance product, which you just testified to you began to use Death Master for in the mid-90s. Was that done in a manual fashion, or was that done in a more systematic fashion?
I don't have personal knowledge of exactly how that particular sweep was done, so I'm sorry, I can't tell you exactly. I don't have personal knowledge of that sweep.
Was there gotta get really close. Was there a point at which Death Master was used in a systematic way with regard to the corporate-owned life insurance products?
It was used monthly. It was part of their standard process.
Okay, and so they would run a match against the corporate-owned life insurance products when they they would run the file against the corporate-owned life insurance products. Is that correct?
To the best of my knowledge.
And what would they do when they found a match?
That would be the first indication that someone may have in fact passed, and I believe they would communicate at that point with the corporate policy owner.
And then what would happen after that?
We would essentially invite the claim and say, now you need to provide the claim form and proof of that.
Did you communicate with the beneficiary or just communicate directly with the owner of the corporate life insurance product?
In that instance, the owner of the policy is the beneficiary. Corporate-owned life insurance, the benefits are paid to the company owner of the policy.
So you would invite them to make a claim.
Yes.
And have you continued to use DeathMaster in this fashion?
I'm sorry, could you clarify?
Are you still using DeathMaster
For
with the
that-
corporate-owned life
Yes.
insurance product?
Yes, sir.
Okay, and do you have any, do you know what the number of corporate-owned life insurance products are that were enforced in the 90s?
I'm sorry, I don't.
Do you have any
I don't
idea
have
what
that.
number of corporate-owned life insurance products are enforced now?
I do not. We'd have to get back to you on that.
All right. Then you've just testified that you've also used it in the disability business. Can you explain how you've used it in that line of business?
Sure. And I'm going to speak at a high level only because we didn't prepare exhaustively for that because it was outside of scope, but I have no problem sharing. I mean, generally, in a similar way to we talked about using it in the annuity business, many disability policies are in force and claims are paid until such time as an individual is no longer eligible for claim. One of the reasons why an individual wouldn't be eligible for claim would be that they die. So in a similar way that I described the annuity business, we're looking to make sure we're not creating duration errors and paying out benefits longer than is appropriate in the disability space.
Do you know when MetLife began to use it for your disability insurance policies?
I don't. We can certainly get that for you. That's not a hard number to find.
Go ahead.
The earliest that I can remember is the early 2000s as well.
Okay.
But
We'll have to fact check that.
Right.
All right, and then with regard to its utilization for your long-term care insurance, can you describe how the companies used the DeathMaster file for that line of business?
Similar type of discussion to disability, and again, I'm just going to give you the high level, which is in many cases in long-term care when someone's in payment status may only exist while the individual is alive. So think about the same logic that I just testified to for the other businesses. I don't have the date when we started. Again, we can certainly follow up and get you that.
And do you know which decade it was that you began to use it for the long-term care insurance?
I do not.
Okay. Any of the witnesses know?
I don't have personal knowledge of the date.
But we certainly can, I mean, that's not a hard one to get you. Even on a break, we can probably get that for you.
And I just want to clarify one thing. The first of our enumerated topics for this hearing in our subpoena is policies and procedures, specific rules, specifications, project descriptions, manuals, and instructions concerning the use of DeathMaster to identify potentially deceased customers across all lines of business.
Okay. So our intent certainly is as best we can to answer all your questions. If we can't answer them immediately, we'd attempt to answer them throughout the day today. That really is our intent.
Okay, so we promised a break at 11. Before we take the break, let me see if the controller has any questions, and then, I've been informed we promised a break at 11. So let me see if the controller has any follow-up questions on this line of questioning, and then we'll turn to Ms. Miller, and then Mr. Hansen, I'm sorry.
One question. This question deviates slightly from the approach that we're taking. We've been going chronologically via business line. My question regards the use of DeathMaster from a holistic approach. So at what level of management was the decision made to use DeathMaster, and how is information communicated across business lines? I'm trying to get a sense of why the different chronologies for the use of DeathMaster.
I understand your question. Unfortunately, I do not know the answer. Many of these decisions were made well in the past, and so as I sit here today, I can't speak to that. The one thing I can speak to, which I'd like to get into some depth later on, is our decision that we made in 2010 to take a more holistic approach to the DeathMaster Index, and I'd be happy to share with you that decisioning process because I was personally involved in it and talk to you how that was made. But I can't speak for kind of what was done historically.
can anybody provide a better sense of the approach, the not working within the insurance industry or in the insurance industry? Is that a lower level management decision, or would that rise to executive management? Would it even rise to board consideration? Is it viewed as a fundamental change in the operations for a particular product line, or is that viewed across company, impacting company-wide operations?
Are you asking it historically? I want to make sure or currently.
You can answer it in a historical context. That's the gist of my question. If not, what would be the current view?
Yeah, so I can't answer it historically. What I can do is, in the context of the current changes, my leadership team and management up to my boss were involved in that dialogue around what we wanted to do there.
And your boss would hold what position at what level, and where's that position in the organizational structure of MetLife?
So my boss is the president of the U.S. business, and he reports to our CEO. And he was involved in the discussions.
Any more questions, John? Ms. Miller?
I just have one clarifying question. You testified that you didn't run through the Death Master the people without Social Security numbers. I think you said 800,000 industrial life policies were in that category. Is that the total number of policies that have never been run through the Death Master, or is that just industrial life?
I believe, and maybe someone can help me fact check that number just to be sure, but the number I was attempting to comment on was the industrial life block. So I assume your question is, are there additional policies beyond those that don't have Social Security number?
Yes.
I don't know the answer to that. We can certainly find that out.
In the 2007 Death Master run, would you go over in detail again what the scope of that was? I mean, what specific policy types and periods of time period they looked at for that?
Sure. The 2007 run, we matched most of our individual life insurance policies. So that would include the industrial, whole life, and any other universal life, the life insurance products normally manufactured by individual business, individual policies.
So that was just life business, individual life?
Specifically with regard to the 2007 match that we discussed, the scope of that was the individual life business, which got materially most of the IB business. There were those small assumed blocks of business which were not matched in 2007 and provided, of course, that we had a Social Security number to match.
So it's just individual life policies where they had a Social Security number associated with the country?
Yes.
Wasn't group, was it a whole term?
Yes, whole life, term life were in scope. Universal life was in scope, but I think we said group life was not in scope of that, and that is because of a very important distinction between group insurance and individual insurance. In group insurance, the company does not keep the records. The group policyholder is the party who generally does the administration of the records.
Where, without running Death Master, what happens in any of these lines of business at MetLife? They go till when? What happens to them long after anybody could possibly imagine a policyholder still alive?
So you're hitting on a very good point, which does it make sense? Well, this wasn't your question, but is there a place to use Death Master in the individual life business? We believe there is. We believe our learnings from the 07 match told us that while 99% of the claim dollars paid, the normal process works, for 1%, it may not. And so we believe it makes sense that, and so to your question, what will happen to those 1%? Those 1% of policies either ultimately would get paid or would superannuate and would be escheated, certainly for the industrial block, which was a big chunk of where our focus was. So I just want to make sure I'm answering your question.
I don't know that you're answering my question. I think I have the same conundrum that Commissioner Jones had, which is claims dollars paid doesn't mean that if a person never submits a claim, I don't know that that's reflected in claims dollars paid, whether it's 99% or...
So I should probably clarify that then. So if you think about over a period of time, we had, I'll generalize, two sources to gather claims. One was the normal process, and the other was out of the death match. So if you looked over a period of time, about 99% of the claim dollars paid came from the normal sources, and about 1%, those claims never were submitted through the normal process, although we don't believe they were, and we caught them through the death match. So we think it's a useful safety net for those situations where the normal process doesn't work.
The other question...
And that match was designed for exactly that purpose, Mr. Hansen, which was to attempt to identify individuals who may have passed, but where the beneficiary did not come forward. And that was actually the purpose of that 2007 match, as a safety net to find anyone that may not have presented a claim to the company.
Well, then my next question is, to your knowledge, who's in the Death Master file? I mean, from what I can tell, it's people that were receiving Social Security benefits.
I'm not an expert on exactly the sources to the Social Security Death Master file. My understanding is that it contains approximately 87 million deaths that were reported in some way to the Social Security Administration.
But you're getting to a good point. There could certainly be people who aren't on the Death Master Index. And this is a challenge for the industry and its regulators, and it's something for us to talk about, because what the policies state is that the beneficiary should submit a claim. We think it's important for individuals to share with their beneficiaries how much insurance they have, so they know they should submit the claim at the time the person dies. We think the Death Master Index is a good tool to capture the majority of individuals that didn't follow that normal process. We think that's a small slice in total. We also think other efforts, like outreach to policyholders, can help there too. So I described the process we did in the 80s and 90s just to reach out to policyholders. We currently match the majority of our admin records against the National Change of Address database to help stay in touch with policyholders. We certainly have robust policies for return mail, so that if we're in touch with a policyholder and we can't get in touch with them. But if your question is getting at what if all of that doesn't work, I mean, ultimately, we can only pay if we're given information that, shows us that there's a liability due. On many of our policies, however, they do superannuate, and all that really means is that at a certain point in time, you assume that you have an unclaimed property situation and that money is turned over to the state.
One other question I have is, what has been kind of, and maybe this is outside the scope of the subpoena or not, but you sold these policies over many years. How are they being marketed to folks? I mean, I look at marketing material and it's like companies make representations. We're there for you. We're going to be there in your, for your family, your estate, or what have you. Is that the general thrust of how you market these life products and annuities?
Our greatest responsibility, we believe, is to make good on our promises to our customers. If we're not able to do that, it would be difficult to ask customers to continue to do business with us. I can't comment specifically to any specific marketing piece, but inherent in what we do is a promise that when we have a liability, to pay that liability. And we pay out over $11 billion in claims. That's what we paid in 2010. Is that the right number?
Yes, it is.
Make sure. So we, in life insurance claims, so we take that very seriously. We also believe the processes around life insurance are quite effective. They work for 99% of the times. There's a small percent where they don't. We think death index is a good safety net. And maybe after the break we can talk about what we are doing now and where we want to go prospectively. We also think continuously doing things to stay in touch with your customers is also a good idea.
Okay, you testified a moment ago that with regard to group life, it's typically the policyholder, which is the corporate entity or customer that has the records. But is there some percentage of your group life business where you actually know who the actual individual policyholder is? And if so, what percentage or number of individual members, if you will, of a group life policy do you have knowledge about?
So the answer is yes, there are some group life businesses where we are managing the records. I don't have the percent of that. We can get you that. But what I will tell you is it's been growing over time where employers may ask us to manage the records. It's relatively small still. But that did lead to our decision in 2010, which I certainly want to talk to, in including the group life business where we had the records as part of our match going forward. And so it's early days on that work, but we think it makes sense to look at that in the same safety net way that I described before. I should make a point that the group business is a little different in that in many situations the employer is the one that submits the claim. So the employer has a role there, and we're very conscious on anything we do in our group business to work closely with our group customers in making sure what we're doing is consistent also with their expectations.
Okay, so prior to 2010, you weren't running DeathMaster against the records you had of individuals who were members of group life policies?
Generally speaking, we were not.
And can you give me an order of magnitude? Is it 20% of the business, 30% of the business, of your group business?
I can't.
Does any of the witnesses know?
It's a minority of the business, but I don't have an exact statistic for you.
We certainly can get you that.
We would like to know that.
Yeah. I want to make a point. We just for completeness, there have been some situations in the group business where a specific group customer has used the match, and in those situations, obviously, we then were presented with claims. So we wouldn't be the one doing the match, but we're aware of certain group customers who have taken it upon themselves to use the death index for their records.
How many?
Not many.
A handful.
A handful is
Okay.
small.
And then you testified a moment ago that for a certain period of time, there were two sources for claims, the normal claims process and DeathMaster. But just to be clear what period of time we're talking about as it relates to the individual life insurance part of your business, it was 2007 that you first began to use DeathMaster in a systematic way across life insurance policies to determine if there were matches. Is that correct?
So in 2007, we did a systematic match. It was one match.
Okay.
But it went back, all the way back on our records.
I understand, but 2007 was the first time you ran that systematic match across life insurance policies where you had a Social Security number, excluding some of the policies that you had testified to a moment ago, the mergers and acquisitions, acquired company policies, and some of the other categories. But 2007 was the first time, and you ran it once that time.
Comprehensive way, individual business with the caveats that you articulated effectively.
Okay, so that's a yes.
Yeah, you didn't say individual, that's why I wanted to clarify.
Okay.
That's a fair
And then when was the next time that you ran DeathMaster across your life insurance policyholders' policies?
Okay, so in 2010, we initiated a comprehensive death match program which I'll ask Mr. Cassandra to talk about, which has us running death index throughout all of the majority of our business. We can talk about exceptions in a minute, in a systemized way. And some of that kicked off in late 2010 for our retained asset accounts, and then it's rolling throughout 2011. And I believe the individual life piece was just matched this month?
Yes.
So, and that will continue throughout 2011.
Okay, so let's start there after the break. And we're going to take a 15-minute break. Thank you very much.
Thank you.